There are two issues that the delegation may have sensed from some of the discussion. One is a sense that there's a repetitive process going on, that you appear before, the state party appears before us, we express our concerns, we make our recommendations, and they're simply not taken into account. They're not acted on, and it becomes a very repetitive process, which may not be, to put it mildly, the best use of resources. And the other is, as one colleague mentioned, that somehow human rights are at the mercy of available resources, which comes particularly strangely from as developed a country as Japan. One issue that particularly raises both problems, of course, is the famous Daiokangoku system. I understand substitute detention means that it's supposed to be provisional, and I believe it was established in 1908, and apparently the resources aren't available to put people under investigative detention and on remand detention in the sort of institutions they should be in if the system were working properly. We're given additional reasons other than resource ones. We're given reasons such as it's helpful for the families and helpful for the lawyers. Again, I find that very difficult, since all the information we have suggests that the families and the lawyers, particularly the Japan Federation of Bar Associations, is in total disagreement and has been in total disagreement for decades. And so it rings a little bit hollow to start hearing those words all again. It is really, we have heard nothing to suggest that this system isn't there and maintained in the interests of a prosecution interested in eliciting confessions from those suspected of having committed crimes. And as such, it is flagrantly incompatible with the covenant. Things that might attenuate it, such as audio-visual recording, well, it's being tried out, but it's going to be more personnel will be needed to make it routine and comprehensive, so we can't afford that, apparently. No lawyers during interrogation. So the delegation shouldn't be surprised if our concluding observations on that particular issue are as strong, if not stronger, than they were before, with a certain amount of resentment at the continuing resistance to listening to us or to the Committee Against Torture or to the rest of the international community raising issues like this. The other key issue that doesn't raise so much the resources question, at least I hope not, but the issue of repetitive cross purposes, to put it no better than that, is of course the issue of the so-called comfort women, and the delegation will understand if some of us are not clever enough to understand the distinction between an assertion that the women were not forcefully taken away, but there's a certain recognition that the process happened against the will of the women. That's what I understood from what was just said to us. This is pretty impenetrable stuff. If there is any doubt that there was sex slavery, by which I mean if there is any doubt that the women were coerced into the activities for which the Konu apology was made in 1992, then it becomes incomprehensible why the government hasn't released the necessary documentation and or hasn't set up an independent, and it would have to be international, inquiry to clarify the matters. How the world is expected to simply take the word of the official version is not clear. And again, it's been just such a repetitive process